Is what you see in Exhibit 17, in your opinion, within Minneapolis Police Departmental Policy 5-300, authorizing the use of reasonable force?
It is not.
That right there, Minneapolis Police Chief Madera Ariondo on the stand yesterday, testifying at day 6 of the Derek Chauvin murder trial, answering several questions about police policy. Joining us now to discuss, one of the world's most well-known trial lawyers, defense attorney Mark Geragos. Mark, good morning to you.
Good morning, Rachel. How are you?
I'm doing well. We heard 3 strong testimonies on the stand yesterday, so let's try to get to those. First, Minneapolis PD's top cop, who we were just listening to, testifying that Chauvin's actions were not in line with the department policies. I have another soundbite real quick.
To continue to apply that level of force to a person proned out, handcuffed behind their back, that in no way, shape, or form is anything that is by policy, it is not part of our training, and it is certainly not part of our ethics or our values.
Now, Mark, something I noticed prior to getting to that very important question, there were so many questions by the prosecution leading up to that, just background information that could have been summed up real quickly. Now, an observation of my own was that it was to build that relationship with the jury so that that moment would have the most impact. He was trusted, he was well liked on the stand, and he was easy to understand. Do you think that was accomplished?
I think it's a very astute observation. I think that's exactly what they were doing. He's a likable witness. He's a engaging witness, and they wanted him to be up there to have the jury engage with him. Now, the downside to that, from the prosecution standpoint, and what has not been really reported on, is that when the defense got up there, the defense was able to do a couple of things. First of all, they established that the chief has not arrested somebody in years. So he hasn't been out on the streets in the sense that he's actually doing policing. Second of all, and I thought a very good point brought out by the defense, was that they established that, look, I know in that spot you just quoted that you said our values or our ethics. What he was talking about and what he got the chief to admit was this employment policy. Employment policy is not what the jury is going to be asked to decide. They're going to be asked to decide whether a reasonable policeman in that situation. And that is not based on Minnesota employment policy. That's why the defense spent so much time sending out or getting the chief to concede that all of these items that he was testifying to on direct to the assistant attorney general were for employment-related decisions.
And speaking of his employment, something else that came out was Ariondo immediately fired Derek Chauvin the day after Floyd's death. So I think a lot of people thought that was a big moment. But to your point, we also saw the defense doing this, last week with the lieutenant, kind of questioning, even though they had so much authority and so much experience, when was the last time you were actually in the field or in that updated experience? Do you think that's really going to play a big part in with the jury? Do you think they're going to pick up on that as much as you did?
One of the reasons that jurors have, there's only been, I think I read somewhere, 95 criminal cases filed against cops in the line of duty. And one of the reasons it's so hard for prosecutors to get a conviction in these cases is that the average juror will sit there and in their mind, they're thinking, how am I going to convict somebody in the line of duty for a split-second decision? And when somebody's looking at it with hindsight. Yesterday, the defense also did that. They actually read from and had the chief to agree with a U.S. Supreme Court opinion on cross-examination. They're going to get some of these things in their jury instructions. And I think people might be somewhat misled as to the strength or the power of the prosecution case. It's great TV, but when it comes to the jury and what the jury is actually charged with doing at the end of this trial, some people may be surprised if the jury struggles a little bit more than the average viewer struggles with their opinion here.
And the average viewer is taking in a lot of other information and commentary after each witness takes the stand. We also heard from MPD's inspector and former trainer. That was Director Katie Blackwell. She said this after being shown an image of Chauvin kneeling on George Floyd. Let's take a listen.
I don't know what kind of improvised position that is. So that's not what we train.
So this is the former director of training. She said it was an improvised position. We heard this discussed a lot prior as well, improvising when out in the field. What was your thoughts on that?
The same thing. I think they're going to be, you have to understand when the jury is charged with this, there's still a presumption of innocence, even though, a lot of people may not like that because it's an officer. But with a presumption of innocence, they're going to get jury instructions. The jury instructions are going to say, or at least the judge will charge them with the idea that an officer can improvise when they're out in the field. Now, when the officer that you just showed said that this wasn't in the training, the defense is going to come back at that, and they're going to say, the training specifically says you can improvise, and you can improvise with a level of force that you think is responsible to whatever the threat is. And that's where the jury is going to have to kind of struggle, if you will, when they come to making a distinction. Obviously, there's a death here, and the jury knows that. So then they have to say, was it murder in the second degree with a state of mind that they have to determine? Was it a third degree, or was there what's called malice, and was this a manslaughter, or was this nothing at all? And I just don't think people, the headlines have been so far in this case, whatever the takeaway is from the direct testimony by the prosecution. People need to watch, I think, at least a couple of minutes if they want to have an informed opinion of what the defense is doing on cross-examination, because there clearly is a method to the madness of the defense.
And clearly a plan in place. We saw that play out with the ER doctor as well, which we don't have time for to get to, but we'll talk about it next time with the way that they kind of shifted the narrative there as well. Mark Geragos, as always, great speaking with you. Thank you.
Great speaking with you too, Rachel. Thank you.